I am Dr. Mohit Saini, Assistant Professor in Law from Khalsa College of Law. Today my topic for lecture is free consent under Indian Contract Act and what is the effect of flaw in consent. As all we know that Indian Contract Act was enacted in the year 1872. At that time it was considered as a mercantile law, but in reality not only the merchant but every person or every individual in his daily life enter into a number of contract by various ways. Although he enters under this contract consciously or unconsciously. For example, when we buy a book or when we got admission in any institute, we enter into an agreement in all such situations. So, in this way, the contracts are very important in our life. Under section 2 clause H of Indian Contract Act, the definition of contract is defined, which provides that any agreement which is enforceable by law is considered as contract. Although all agreements are not converted into contract, only those agreements which fulfill the requirement of section 10, which are provided under Indian Contract Act, those agreements can convert it into contract. And section 10 of Indian Contract Act provides about some requirements which are as follows, like there must be two parties for creation of any contract. There must be offer and acceptance between the parties. There must be lawful consideration between the parties. There must be lawful object for creation of contract. There must be free consent between the parties. Parties must be competent for creation of contract. Now, during competency, now who are competent for creation of contract in India? Any person who is of sound mind, any major person or any person who is not disqualified by law under whom he is a subject. These persons are competent for creation of valid contract in India. After that, there must be lawful object and consideration between the parties. There must be legal intention between the parties for creation of a valid contract. And one of the major source for creation of a valid contract is free consent. So, free consent is one of the major essential for creation of valid contract. Section 14 of Indian Contract Act provides that what is free consent. So, the consent of the parties must be considered as free when it is not obtained by coercion, undue influence, misrepresentation, fraud or mistake. If the consent of one of the party has been obtained by any of the above stated means, the consent is not considered as free consent, which is essential for creation of a valid contract. Now, I am going to discuss all about these things in detail. So, first of all, coercion. The term coercion is defined under section 15 of Indian Contract Act, which provides that any act by which one party try to commit or threatening to commit any act which is forbidden by the Indian Penal Code. Any act by which party try to detain unlawfully or threatening to detain unlawful the property of another person, that is considered as coercion. For example, if any person has threatened another for committing suicide, if he has not transferred him unlawfully any property, this is considered as an act of coercion under Indian Penal Code. So, the first requirement for filing a case under coercion is that the party act in such a way which is forbidden by Indian Penal Code. The second requirement for filing a case under coercion is that unlawful detaining the property of another person. So, coercion could also be caused if by unlawful detaining or threatening to detain any property with the intention of causing any person to enter into an agreement, your act is considered as coercion, because the word coercion is similarly used in England, but there the term is used as duress. The main difference between duress and coercion is that the concept of coercion in India is much wider as compared to to duress under English law, because here in India coercion include threatening or detaining. Second point is undue influence under section 16. So, a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the party is in a position to dominate the will of another, and he has uses his position in such a way that he has gained some unfair advantage against another. So, here a person is deemed to be in a position to dominate the will of another, where he hold in a real or apparent authority, where he make a contract with a person whose mental capacity is temporary or permanent affected due to his old age or by reason of illness or any other type of bodily disease. So, in case of where a person is in a position to dominate the will of another and the contract clearly on the face of the record provides that one of the parties is in a position to dominate the will of another. So, in such situation, the party who is in a dominant position, he needs to prove that he has not taken any advantage by his position under Indian Contract Act. The third requirement where your consent is not considered as free consent is case of fraud. Now, fraud is defined under section 17 of Indian Contract Act, which provides that if a person has obtained the consent of another person or any agent of the person has obtained the assent of any third party by any such statement which that person himself knows that the statement is not true. In such case, the consent is not considered as free consent, which is essential for the creation of valid contract. So, in case of fraud, the person has intention to gain an unfair advantage at the cost of another, which is not considered as a free consent for creation of valid contract under Indian Contract Act. And the next requirement is misrepresentation under section 18. If any of the party gives any statement which he himself believes that the statement is true, it means in case of misrepresentation, the innocent misstatement which the person who gives the statement himself thinks about that the statement is true. In such cases, the consent if obtained by the person from some another person, the consent is considered as free consent. But in such cases, no valid contract has been obtained between the parties. Fourth point is misrepresentation. So, an innocent misstatement or false statement, this is known as misrepresentation. So, in misrepresentation, person making the statement consider it as true and he has no intention to deceive the other party. So, his statement is false although he himself believes that the statement is true. This is the major difference between fraud and misrepresentation, because in case of fraud, the person has intention to deceive the another party. So, that is why he make a false statement which he himself know that the statement is false. But in case of misrepresentation, person himself believes that the statement is true. So, this is a major difference between misrepresentation and fraud, because in case of fraud, party has intention to deceive the another party, but in case of misrepresentation, party has no intention to deceive the other party. Next point is mistake. Now, when the consent of parties are caused by mistake, the consent is not considered as free consent, which is needed for the creation of valid contract. Now, in case of mistake, one or both of the parties are working under some misunderstanding or misapprehension of some relating facts. So, mistake may work in two ways between the parties. First is mistake in mind of the parties is such that there is no genuine agreement at all, or there may be no consensus ad idem which is necessary for creation of valid contract. And the second is there may be a genuine agreement, but there may be mistake as to matter of fact which are required for the creation of valid contract. Now, the question is, what is the effect of flaw in consent upon the contract? Section 19 and 19A of Indian Contract Act provides that in case your consent is obtained under coercion, undue influence, fraud or misrepresentation, the nature of contract is declared as voidable. But if your consent is obtained by mistake, the nature of contract is declared as void. So, for creation of valid contract, free consent is one of the major requirement, or if in any case your consent is obtained by any of the above means, the consent is not considered as free consent. So, in case of flaw in consent, one party or the other may have either some remedies. So, he has right to rescission of contract, that is contract may be voidable at his option, or he has a right to claim compensation from the another party. Although there are some limitation upon the right of rescission, like when the contract is affirmed by the party, he has no right to rescission of contract, or when there is a lapse of time, means when you have not provided his consent or not taken an action within a reasonable time, you have no right to challenge such contract. And third is acquisition of right by third party. And next is inability to restore the goods. When the parties are unable to restore the goods in their original position, then they cannot exercise their right under this act. And the last one is to claim compensation in place of rescission of contract. Compensation is one of the major remedy in case of breach of contract by any of the party. So, by providing compensation, court try to create an equal position between the parties and provide some remedy to the aggrieved person. Thank you.